Hey boys and girls, today we are going to talk about trial bundles. Now, this video is especially important for those people who are litigants in person. That means conducting a lawsuit, a trial by themselves without the help of a lawyer usually because of financial reasons. Now, so today's topic is the trial bundles. These are trial bundles and I will go through them one by one. So, trial bundles are essentially all the documents likely to be referred to at trial, and they should be placed in a paginated trial bundle, a bundle like this, for use by the judge, the witnesses, and other relevant parties to refer to. So usually the plaintiff, the person who starts the lawsuit, usually the plaintiff files all the bundles except for the defendant's bundle of authorities and the defendant's bundle. Therefore, if you are a plaintiff, there is more work for you to do because you have to file more bundles. And if you engage a lawyer to conduct the trial for you, he would charge more because there's more bundles to be prepared. Now, there's a reason why there are red and blue spines for the bundles. The red spine is for the plaintiff and the blue spine is for the defendant. Oops. So, usually each party will prepare 4 copies of the bundles. 1 copy for himself, 1 for the other lawyer, 1 for the judge, and 1 for the witness. The first bundle that I will talk about is called the setting down bundle. The setting down bundle, which is always prepared by the plaintiff, contains the pleadings, which means the writ of summons, the defense or and counterclaim. You can watch the video below on pleadings. The reply and defense counterclaim. It will also contain the further and better particulars that is requested by both parties, and if there's a summons for further and better particulars and an order of court ordering the production of further and better particulars, it will be set out inside. There will also be an order containing the names of all the witnesses in the trial and the date of set down. The next bundle that I'm going to talk about is called the agreed bundle, which is also prepared by the plaintiff. The agreed bundle is a bundle of all documents that are agreed by the parties to be used in connection with the trial. And it usually consists of the items disclosed by the parties during discovery. Discovery is essentially the process whereby each party discloses documents in their possession that are relevant to the lawsuit. So, before the trial, the parties would usually agree on the authenticity, that means the genuineness, and the admissibility of the documents. If there is no dispute on the authenticity and admissibility of the documents, then it will be included in the agreed bundle. So a party does not have to prove the admissibility of a document if it is agreed to be included in the agreed bundle. Documents that are not agreed between the plaintiff and the defendant to be included in the agreed bundle because there is a dispute on the authenticity or the admissibility of the document in question will be included in a separate bundle called the plaintiff's bundle or the defendant's bundle. So for the agreed bundle, there are usually several volumes because there will be a lot of documents. So there will be volume 1, volume 2, volume 3. And the numbering across all the volumes are continuous. That means if the last page of volume 1 is page... So if the last page of volume 1 is page 201, then the first page of volume 2 will be 202. So the plaintiff's lawyer will usually circulate the contents page to the defendant's lawyer before the trial to review and confirm that all the documents that have been disclosed are in the agreed bundle. So, the index page for the agreed bundle will state the date of the document, the description, for example, an email dated the 21st of May 2018, or an invoice, a WhatsApp message, a photograph, or an agreement. So, and it will also state, the index page will also state whether it's an original or copy. Most of the time, there are copies if both parties don't dispute the genuineness of the document. Then there will be corresponding page numbers, okay, for the relevant document. And the parties have to also ensure that there is no duplication, because sometimes both parties have the same document. For example, an agreement or an invoice, and both are disclosed in each other's list of documents. So you don't want to have the same document included twice in the agreed bundle. Now I will move on to the bundle of Affidavit of Evidence in Chief. As you are aware, an Affidavit of Evidence in Chief is an affidavit, a sworn statement by a witness narrating his version of events, what he witnessed. It is different from a normal affidavit used in interlocutory applications. So, because the Affidavit of Evidence in Chief can only contain facts and not opinions, speculation, blah, 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 blah. So, the bundle of, I will call it I'll abbreviate it as AEICs. So the bundle of AEICs will contain the AEICs of all the parties' witnesses. There'll be several volumes depending on the number of witnesses. So there'll be volume 1, volume 2, volume 3, and just like the agreed bundle, there'll be continuous numbering across all the different volumes. The next bundle that both parties have to prepare are the bundle of authorities. Now, what is a bundle of authorities? Well, it's basically a bound document containing all the cases, the legal cases, the statutes, regulations, textbooks, and reference materials relied on by that party. For the High Court, the lawyer or the litigant in person has to give a description under the index page, the table of contents page, of the relevance of that particular case, the relevance of that statute or the textbook. Okay, this is not necessary for the state courts, the lower courts. So for the High Court, including irrelevant or duplicate authorities can lead to an adverse cost order for basically giving multiple case law basically for the same proposition. Where there are multiple volumes in the agreed bundle, parties are encouraged to have a core bundle containing the documents where the parties need to continuously refer to. For example, a main contract that is at the center of the dispute, or to a guarantee, or to a particular WhatsApp message that is the focus, the core of the dispute. So on the first day of trial, before the trial actually starts, the judge will spend the first 5 to 10 minutes marking up all these bundles. So for example, the set down bundle may be marked as SDB, set down bundle, and the agreed bundles can be marked AB1, which is agreed bundle volume 1, AB2, agreed bundle volume 2, AB3, agreed bundle volume 3. So during cross-examination, the lawyer can tell the witness, can you please refer to AB2, page 453. So the witness, the bundles will be in front of the witness. He will take the bundle called AB2 and he will turn to page 453 and look at the document in question, or being cross-examined by the lawyer on that document. So thanks for watching this video on trial bundles.